The court calls case number 19-CV-484, Andrew Colborn versus Netflix et al. Appearances, please, starting with plaintiff.
April Barker appears on behalf of plaintiff Andrew Colborn, along with co-counsel Michael Griesbach.
Yes, and Michael Griesbach appears, Your Honor, both as co-counsel for Mr. Colborn, but also as the respondent in the subpoena at issue here.
This is Lita Walker from Ballard Spahr on behalf of Netflix, and also on the line representing Netflix is James Friedman.
This is Megan Fenslow of the law firm Dassey Vic Carolyn, appearing on behalf of the producer defendants, Chrome Media, Laura Ricciardi, and Moira Demos.
So, good afternoon, counsel. We are here for a continued motion hearing. By way of background, this is a defamation case. The complaint was initially filed in December of 2018. It relates to the Netflix series Making a Murderer and Making a Murderer 2. The case was removed to federal court in April of 2019. There was a second amended complaint filed in January of 2020. Motion practice, case got reassigned to me in September of 2020. We had an order denying motions to dismiss. We set a schedule. And then, as is most relevant to today's proceedings, on March 22nd of this year, Netflix filed a motion to compel, seeking a court order compelling respondent Michael Griesbach, who was co-counsel for the plaintiff, to produce documents responsive to 11 requests that were attached to a subpoena. As I mentioned, respondent is co-counsel for the plaintiff. He's also a former assistant district attorney for Manitowoc County and was involved to some degree in the events depicted in the series that are at issue. He's also the author of at least 2, maybe more books on the events that are described in the series that are at issue. According to the motion, the respondent filed an objection to the subpoena and refused to produce any documents. There were other discovery motions that were filed. Those have all been resolved. On April 13th, the respondent filed an opposition to the motion to compel, arguing that counsel's opinions should not be discoverable because they're not relevant, arguing that the subpoena was, I think, served for an improper purpose to raise potential ethics conflicts in respondent's continued representation of the plaintiff. Also argues that the documents that are responsive are all otherwise publicly available. And then also raised a fifth point that the Wisconsin statute 88514, reporter or news person's privilege, precluded or protected the items from discovery. On April 26th, Netflix filed its reply, challenged the respondent's objections, and we had a hearing on May 25th. The court heard argument on all of the multiple pending motions. As I said, I resolved 4 of them. But given the issue of the reporter's privilege with that section 88514, the court asked for additional briefing on that issue, or on that objection and its applicability to the subpoenas. I can set this as a continued hearing following the submission of briefs. On June 3rd, the respondent's counsel, who had represented him in connection with the objections and in the first hearing, withdrew. Court or moved to withdraw. The court granted that motion. On June 8th, Netflix filed its supplemental brief and a supporting declaration. On June 9th, the respondent filed a supplemental brief and declaration. It's a day late, but looks like there was just an issue in getting it filed electronically. There was a motion to extend time, which the court granted, and it wasn't opposed in any event. And I frankly don't want to, we don't need to dwell on the timing there. So I will consider all those briefs fully filed. So we've got 3 briefs that were filed, one in March, one on April 13th, one on April 26th, and then one on June 8th and one on June 9th. The court has reviewed them all, and in particular is interested in discussing the news person's privilege, reporter privilege statute, and its applicability to the subpoena. Although, as I think I indicated last time, I was not terribly persuaded by the other objections to the subpoena, but I guess I haven't technically ruled on those yet. So that is the background as far as the court's aware. Any updates from the parties before we proceed further?
No, Your Honor. On behalf of Netflix, nothing.
Nothing on behalf of me, Your Honor, the respondent, Mike Griesbach.
Okay. So,
in terms of updates, sorry.
Yeah. Well, thank you. So let's focus on the statute here. I'm glad that I pushed this off for a few weeks because this is it's an interesting statute. It's very strangely written, I guess I'll say. On one level, it's interesting that it does not use the word reporter and it does not use the word privilege. But the court will assume that it does create a state law privilege for reporters or for news persons, as the statute, the term the statute uses. That is applicable in this court under Federal Rule of Evidence 501. As I read the statute, it really isn't. I mean, it is written in an interesting way, and it tries to set up a state court procedure that limits or regulates the issuance of subpoenas to news persons. Before we discuss the statute and whether it applies or whether it's been waived, let me give you my sort of quick walkthrough of the statute to sort of set the stage. So, subsection 1 of the statute defines news person, and that's it's not. I guess it's a term, but it uses 2 words instead of a single word, even though news person, I think, is a word. That's curious. Not particularly relevant, but it's curious in terms of drafting. I also find it curious that the statute defines news person first by reference to entities, by businesses, organizations, rather than individuals or persons. That's curious. And then it proceeds to include also persons, individuals who essentially engage in gathering, receiving, preparing, or disseminating news or information to the entities that are described in subsection 1A. Again, I can't help but just note what a strange drafting job this is, given that it goes to entities first, then to persons to define the news person, and then also doesn't describe reporters or really investigating. Anyway, subsection 2A then prohibits persons who have the power to issue subpoenas, presumably lawyers, from doing so with respect to certain subpoenas to news persons. And it applies to subpoenas that seek testimony or documents that disclose 4 different things, the first 3 of which really relate to confidential sources. The identity of confidential sources, information that could tend to identify a confidential source, or 3, news or information obtained or prepared in confidence. So essentially, I assume like off the record, confidential information that was shared with a news person. The fourth subsection of 2A applies more describes more generally news or information or the identity of any sources of news or information. So that's much more broadly items that a reporter or news person might gather or prepare. Subsection 2B then provides the procedure for circuit courts to issue subpoenas and to compel testimony or disclosure from a news person of news or information falling within the fourth category, which is the broader one, not the confidential source subsections. So presumably the confidential sources, the first three subsections of 2A are just off limits entirely. The fourth subsection of information can be the subject of a subpoena from a circuit court if, after notice in a hearing and a finding based on clear and convincing evidence, the court determines that a crime has occurred or a civil complaint states a claim upon which relief can be granted. And the court also has to find that issuing the subpoena would satisfy four other conditions. The information has to be highly relevant, necessary to a party's claim or defense, or proof of a material issue. It has to not be obtainable from an alternative source, and there must be an overriding public interest. So that's sort of the way this privilege works. It's really to the extent one calls it a privilege, it's really a procedure to protect news persons from subpoenas. Subsection 3 then prohibits the issuance of subpoenas to third parties who are not news persons, and it is prohibited from serving such persons with a subpoena to testify or produce information relating to a business transaction with a news person if the purpose is to discover information that otherwise falls within one of the confidential source disclosure limitations, so 2A 1.1 through 3. But that subsection does not apply to 2A4. That's curious. Subsection 4 then provides that disclosure to another person or dissemination to the public of news information or the identity of a source by a news person is not a waiver. Subsection 5 provides that information obtained in violation of this statute is inadmissible in court, legislative, or administrative proceedings. So that's my, as I said, it's a curiously drafted statute. It's written very indirectly, but that's how I sort of read the statute. Before we proceed any further, I'll give both counsel for Netflix and counsel for and Mr. Griesbach, the respondent, a chance to correct me or clarify anything if you think I've missed anything in my description of how this statute is drafted and how it appears it's supposed to work. Ms. Walker?
No, I think you've summarized its plain language pretty well. The only thing I would add, just because you noted it was so curious, is how news person is defined. And having dealt with these statutes a lot, I would just tell you defining who is a member of the media and who is a journalist can be a very fraught endeavor that raises many constitutional issues. And so my guess is that's why news person was defined in the roundabout way it was, to avoid those thorny questions.
No, I get it. It seems odd to me, though, that one wouldn't say news person includes a reporter or a journalist. but anyway, thank you. Mr. Griesbach, any comments or corrections?
Only, Your Honor, that I looked at the legislative history, and it gives no more clarification as to why it's drafted that way. There really isn't much, at least that I was able to find in terms of legislative history or case law, specifically analyzing Wisconsin's reporter privilege statute. As per news person, I don't know if counsel for Netflix is in agreement or not. I don't think that's been an issue so far, but that I, as the writer of these books, which were published as defined in one of those subsections, would be considered a news person. But maybe that's
I don't think there's an issue. I don't think there's an issue on that. And I wasn't trying in my walkthrough of the statute. I wasn't trying to signal any sort of rulings. I was just trying to sort of lay out my understanding of this really curiously worded statute.
Agreed, Your Honor. It is a hard one to follow.
And I spent several years on the bankruptcy court bench, so I'm familiar with the bankruptcy code, which is an incredibly, in many ways, challenging statute to interpret.
Mm-hmm.
But we'll leave that to one side. As I said, I've read your briefs. I have a few questions. So with respect to Netflix's supplemental brief, Netflix, as I understand, argues waiver that any invocation, any protections by this news person privilege statute has been waived on two different grounds. One, because respondent did not raise it timely within the meaning of the rule governing within Rule 45b2b, and second, so that's more of a procedural waiver, and second, a substantive waiver that by respondent having joined plaintiff's legal team, doing so consistent with the analysis in the Simon versus Northwestern University case, that waived any ability to invoke the privilege. Netflix also encourages the court not to, and I probably scared Ms. Walker by going through by walking through the language of the statute, because Netflix does not want me to wade into the waiver or the balancing test that is set forth in subsection 2B and 2C. And I understand, so the Netflix would have me not do that, although arguments could be made under that provision as well. Ms. Walker, do I have basically the overall outlines of Netflix argument correctly?
That's right, Your Honor. I would add two things. One is the parties are in agreement that the issue of privilege and its waiver are at most only relevant to requests 1 through 6 in the subpoena. Mr. Griesbach does not raise the privilege as to the remaining requests. And then while I completely agree that Netflix is not questioning that Mr. Griesbach fell within the author of news person at the time he was authoring his nonfiction books, and we're not suggesting he was not a news person at that time, when you look at the waiver provision, and you read this, it talks about a disclosure by a news person, and our position is that at the time we served the subpoena and the disclosures that are relevant to us were not by Mr. Griesbach in his capacity as a news person at that stage. He was disclosing information, and the waiver has occurred because he disclosed it in his capacity as counsel of record. So I just wanted to clarify that, but I assume you may have more questions on subdivision 4.
So let me take things more slowly. Let's deal with the timing, the procedural waiver first. I guess my primary question for Netflix is that there may have been a technical failure to waive this or to raise this objection within the time limits required by the rule. Has Netflix been prejudiced by that? Can Netflix point to any prejudice from the timing?
Well, I don't think prejudice is required under the strong Seventh Circuit case law we cited. But to answer your question directly, I think there is some modicum of prejudice in the fact that, you know, we received written objections and we had a meet and confer, and it wasn't until nearly a month after we served the subpoena that Mr. Griesbach's counsel first raised the notion of privilege. And the case law we cite is pretty clear that that's prejudice or no, that's a waiver. The other thing I would note, and this is in a footnote in our supplemental brief, is it's really inexcusable that they didn't. The reporter's privilege, the statute, has been sort of ever present in this case from the very beginning. Obviously, you've got filmmakers and content creators sitting on the defense side. And as we noted, Mr. Colborn, you know, withheld a whole bunch of documents right around the time Mr. Griesbach was putting his objections together on the basis of reporter's privilege. And so it's really inexplicable that if Mr. Griesbach thought this applied to him, that he didn't raise it. And we don't think a showing of prejudice is required, but we do believe there has been at least some in having to play this sort of cat and mouse game.
But other than so it came up late, and you've had to fight about it. Okay, if it had been raised, you know, on the last deadline, I forget how many days it is the rule provides, but let's assume that it was raised on the last day. I mean, would Netflix be sitting in any different position today than it is now? And I appreciate your arguing that it doesn't require prejudice. Let's put that issue, put that legal issue to the side. I want to know, like, how is Netflix harmed by the fact that this, you know, there was perhaps a screw up by counsel and this thing did not get included in the written objection, and it was raised, you know, a few weeks later?
Yeah, I mean, it's not significant. I'll not stand here and suggest it was, other than it's added expense and some delay, and you know, we're going into Mr. Colborn's deposition in about a month. But the prejudice has not been hugely significant. I agree with you.
All right, thank you. Sort of tagging onto a comment you made just now. And I didn't see any reference to this in any of the parties' filings, but have Netflix or the producer defendants invoked this statute in response to any of plaintiff's discovery requests?
It has been as a form objection, but no one has withheld, no defendants, to my knowledge, and Ms. Fenzel can speak for the producer defendants, but certainly not Netflix, has withheld any journalistic work product pursuant to the privilege. As you can imagine, it becomes difficult to assert when the journalist is the defendant. Not impossible, it can be done, but Netflix did not do it here.
And Your Honor, this is Ms. Fenzel on behalf of the producer defendants. I can confirm that the producer defendants have again referenced it in objections, but have not forcefully asserted the privilege here.
All right. Thank you.
Your Honor, this is April Barker, counsel for the plaintiff. I just want to be clear for the record, to note for the record, and to be completely candid, I don't have the exact specifics at in my recall, but there was a document, a brief that I think pertained possibly to the our motion to compel initial disclosures, in which I do recall we had to brief that issue against the Chrome defendants, I think only. I don't think it was a basis of a ruling by the court, and I think the issue kind of faded away, is my recollection.
Yeah, I certainly don't remember it. And again, it struck me as I was analyzing the statute and the issues in connection with this motion that, based on the definition of news person, obviously it would seem that would apply to defendants as well, and whether the exceptions to the within the statute would cover this or not, or whether there's given the fact, it struck me that there's a completely 180 of how this might apply in the reverse direction.
Yeah,
just curious. Go ahead.
I apologize, Your Honor. I know that I did draft a brief in which we responded to it and cited an informal guide in Wisconsin that indicated that it did not apply to media as defendants in, for example, a defamation case.
All right. Another question on something that is I didn't see addressed in not that it would be addressed in the parties' materials, but the materials that are requested in the subpoena, were these same materials covered by any of the Netflix's or the other defendants' requests to the plaintiff himself? And I ask that because I wonder whether if these materials are within counsel's possession, aren't they within the possession, custody, and control of the plaintiff? But because counsel is plaintiff's agent, such that a subpoena was essentially not necessary, that they could have been requested directly from the party, and that might take Section 88514 completely out of the picture. Ms. Walker?
Yeah, that is an interesting question. I think some, but not all, of what we are requesting from Mr. Griesbach is in the plaintiff's possession or is available from other sources, such as various court records, the search warrant, the deposition Mr. Griesbach gave, correspondence he had with the filmmakers about his appearance in Making a Murderer. And so some of that is we already have and have gotten it from other people, and certainly we don't need Mr. Griesbach to give us duplicate copies of that. Requests 1 through 6, which really go to information he gathered for purposes of writing his books and is now using in pursuit of a defamation claim on behalf of Mr. Colborn. I don't know that your theory occurred to us. It's certainly a good one and an interesting one. I highly suspect it would have been met with similar resistance in a statement that Mr. Griesbach was not Mr. Colborn's agent at the time he gathered them, and they don't belong to Mr. Colborn. They continue to belong to Mr. Griesbach. But we didn't pursue that quite as directly as you're suggesting.
Yeah, because the thought occurs to me that, it gets to the extent that these materials are out there, and again, I don't even know. There's a lot of sort of broad brush discussion of these materials. I don't know what exactly is covered by these subpoenas, what exists, and what would be produced, or any of the specifics. But it seems to me that if those documents or materials are out there and they are in Mr. Griesbach's possession, and as a result of that, plaintiff has access to them and could make use of them affirmatively if he chooses, or bury them if they are not helpful, that the plaintiff's access to them inherently means that, again, the plaintiff has possession, custody, or control over them because his agent does. So if defendants ask for them up from the plaintiff in document requests, Rule 35 document requests, the plaintiff would have to produce them. Again, whether they were helpful or harmful, they would be subject to discovery. And it seems to me that this whole reporter privilege or news person's privilege statute would not come into play if that were the route we were approaching this.
Your Honor, could I interject on behalf of the plaintiff?
Just wait. I'll get to the plaintiff in a bit.
Okay. Thank you.
But so that's I don't know. That's one way I thought about it. And it really comes up similar to the point I think Netflix argues, cites to some cases that talk about using privilege as a sword and a shield. And really what that is intended to, I think what that concept is intended to get at is it's not fair for one side to have access to documents or information or materials and then to be able to cherry pick only the useful stuff to disclose and use in litigation, while anything harmful gets buried and is not shared. And to me, this is another way of getting to that same result, avoiding that same unfairness. I think those are all the questions I have for Netflix counsel. One more, Ms. Walker. So the statute, as I said, there's a sense in which it's a privilege. There's a sense in which it's really a state court procedural mechanism that creates protections in connection with the service of subpoenas on news persons. I take it Netflix would concede that they did not follow the pre-subpoena procedures that are set forth in the statute. How does that failure play into all of this, if at all?
Sure. So I think it's fair to characterize the privilege, even though that word is not used in the statute, as a substantive creature of state law, and we haven't found reason to cite it, but there's plenty of case law saying that in a diversity case, state law applies and the state reporter's privilege applies. But as you point out, there are procedural aspects to the statute involving application to the circuit court, quote unquote, before issuing the subpoena. We did not go to the circuit court, which is the state court, before issuing the subpoena. I think that's a procedural aspect that doesn't apply in federal court, and the plain language of the statute suggests that. It refers to circuit courts, which is what Wisconsin called its state court. So I don't think that procedure is required or envisioned by the federal rules of civil procedure, but we didn't do it. And the other argument I would raise on that is, if Mr. Griesbach or his then counsel had thought that we should come to you and ask for permission to serve a subpoena, they really should have raised that back on February 10th or whenever it was we served this thing. And the end result is we would have brought the motion now before you back in February instead of March. But they didn't, and they didn't raise it in their written objections. They didn't raise it in their opposition at the meet and confer, in their strict and sur reply, or frankly, even on May 25th, we're seeing this argument for the very first time in the brief they filed 5 days ago. So I think you should dismiss it out of hand, and I think just given the procedural nature of that aspect of the shield law, reporter's privilege, it applies to circuit courts, but it doesn't apply in federal court.
Thank you. The part that's complicated is that because of the way the statute is structured, there's no substantive provision separate from the procedural provision. It's sort of all baked together. That being said, I will agree with you that the failure of respondents to raise this issue at the start has prejudiced Netflix. I mean, that's a waiver. I mean, that's a waiver, not having raised that 3 months ago and then waiting until the end to raise it. That puts you in a different position. But thank you for that. That makes sense. Ms. Barker, you wanted to say something on behalf of the plaintiff. Please go ahead.
Thank you, Your Honor. Yes, briefly, with respect to the issue about whether everything that is in Mr. Griesbach's personal position is available to Mr. Colborn, as counsel for Mr. Colborn, I would say that that's certainly not been our thought process, and my thought would be that an agent is imputed to have possession and custody of whatever its principal does, but that the reverse may not be true as to an agent in their personal capacity. So, for example, I have written articles for the Wisconsin Law Journal in the past. I would not expect that all of my research is something my clients could demand that I give to them in their cases, even if it somehow bore on it. So it has never been our thought process that we had access to everything that Mr. Griesbach may have in his personal capacity, and I'm not sure that that's, that we would agree with that assessment of the legal ramifications of the agent-principal relationship. But as a practical matter, if someone, we have obviously had occasion to comb through what information Mr. Colborn has personally, and at least as to what is personally available to him, we also would, I can say that if that theoretical document request were made, that our response would be that the plaintiff does not have such responsive documents in his custody or possession. And again, the question of access, I guess, it's not been our thought that we had the right to demand of Mr. Griesbach that he unhand everything in his home.
Right. Well, and it's a well. First, before I go much further, there's some background noise that has been coming on the line from time to time. If you're not talking, it would be helpful if you could mute your phone. Thank you. So let me also. So the general rule, as I understand it, obviously there's a principal-agent relationship between a client and a lawyer, and the lawyer is the agent of the client, and that doesn't make the lawyer's private property within the custody and control of the client, obviously. But if there are materials that relate to the client's case that are within the agent's possession, if the principal, if the client can obtain custody of those materials by asking for them, and I think they are within the agent's custody or control. And to the extent those are materials that would be helpful to the client, I think the lawyer as agent would have an ethical obligation to provide them to his client. And that being the case, I think if there are harmful materials out there, you would have the obligation to provide those to the client as well, so the client is forewarned. But again, we're talking about an alternate reality that's not really before the court right now.
Your Honor, could I add anything here, or would you like to move on?
Briefly, please.
Yeah, I mean, Netflix, it's sort of tomato to Netflix. If Colborn wants to produce these because he has access to them, that's fine. I mean, discovery has closed, so if you want us to go that route, we'd ask that you reopen discovery and order Colborn to comply with such requests. Otherwise, we're happy to get them from Mr. Griesbach directly. I think what matters here is what Ms. Barker just said, which, if I heard her right, is that, occasionally they've had reason and opportunity to comb through Mr. Griesbach's documents. And so there's no doubt that Mr. Colborn is using Mr. Griesbach's body of evidence and body of knowledge gathered as an author to now prosecute a case for millions of dollars against Netflix, and that's what matters is and that's why we're entitled to this, whether it's through party discovery or through a subpoena to Mr. Griesbach, because he's waived it.
Your Honor, if I might, that's absolutely not what I said as Attorney Barker. We have not, is what I said, had occasion to ever think that we had access to Mr. Griesbach's personal documents. Frankly, we have opposed having Mr. Griesbach's personal documents be something that we need to do a sideshow and a detour of this case with.
All right. All right. Again, there's some ethical issues with that too. I don't know that you, as a lawyer, you can close off your client from that, but that's neither here nor there. Let's not get further distracted down this rabbit hole. So, Mr. Griesbach, I now have some questions for you. Let me first confirm that you indicated in the response you filed, the supplemental brief you filed, I think, that the reporter's privilege does not apply, you agree, does not apply to document request number 7 through 11. Is that correct?
I did, Your Honor, although 11 is a little confusing because it doesn't really specify what documents it's looking for, just communications with 12 or 15 people. So it's hard to say if those involve documents or communications with regard to my books or what they involve. But to the extent they don't, that 11 does not ask for those things, that's correct. I concede and agree, and frankly, it should have been made clear earlier with counsel that the reporter privilege objection really only goes to their document request numbers 1 through 6.
So my next question is, so I assume that it's still the case that no documents have been produced. Is that correct? In response to that?
It is, Your Honor. I thought of reaching out to Netflix, but this came on awfully fast, and I thought it's probably better to see where we're going today. Frankly, I can concede. I get, especially with respect to numbers 8, 9, and 10. Where they've arguably shown the relevance even under the kind of broad standard of pretrial discovery, specifically anything I prepared in any communications or documents I prepared for the Attorney General in their independent review of the Avery wrongful conviction case in 1985. And number 9, having any documents I prepared or communications with regard to my deposition in Mr. Avery's civil wrongful conviction lawsuit. I get that there may, there's potentially, or at least the argument that that is relevant, even on especially on a pretrial broad discovery relevance scheme. And then as to number 10, any documents or communications I consulted in preparation for the search warrant, which occurred on the very first day at the Avery salvage yard when the vehicle was found. I understand those things, and I understand, frankly, that the court is likely and really don't, frankly, I don't object. I should add, though, Your Honor, and this isn't just the reason I'm not objecting to that. I don't think, I will check again, but just recalling those 3 issues, I don't believe I have any such documents. I testified at a deposition. I didn't prep it. I might have one communication with an attorney general just saying, meet me at this time, at this place. The AG representing me, I should say, they have to represent ADAs when they're deposed, I guess. And the same thing with the search warrant. The way it works in the field, at least in state court, regular state prosecutors, when there's a bunch of cops on a scene looking at evidence and you're trying to assist them in terms of what you're supposed to be doing there if there's grounds for a search warrant. I certainly don't have any scratchy notes that I would have had then, outlining, I should say, why kind of the factual basis for a search warrant. And the same would hold true with, I guess that's the three of them. But yeah, I do understand the relevance of those three, 8, 9, and 10.
So somebody's. Let me say this. The discussion you just had, the recitation you just made with respect to the specifics of these requests and what you have and what you may not have, what you probably don't have. I find it incredibly, incredibly frustrating that this is the first time that we're hearing any of this. There's this boilerplate objection raising a number of issues about undue burden and overbreadth, and through all of the briefing up until when you just spoke, there was literally nothing from the respondent's side addressing the specifics of the request, of these requests, and saying what you can produce, what you can't produce, what's available. That is what should take place before the objections are served. That's what should take place in a meet and confer before motions are filed with the court. Because again, if there's no documents responsive, we all wasted a whole heck of a lot of time over nothing. And so that is the type of discussion that needs to happen before we get to the second hearing on this. It's also the type of analysis that should be done before objections are filed. And certainly after there's initial briefing on a motion to compel, and then there's supplemental briefing, now to come up with that, I mean, it's way, way, way late in the game, and it's really frustrating as a judge to hear that.
I understand that, Your Honor. The only thing I would respond with is the vast number of documents requested here. The other requests, what would it be, 6 requests, or excuse me, 8 requests, is really the issues up for debate, and those are, I don't think it's a waste of time for me to have objected and to, you're right, my counsel or I guess, should have vetoed his view of this and said, look, 8, 9, and 10, certainly those, respond to them. I relied on counsel. That's not an excuse, but the court could probably tell, way of lawyering, it was quite a bit different than mine. But obviously the objection, at least I think the objections I'm raising to them requesting things like outlines, treatments, draft manuscripts, emails with my agent, marketing promotion of the book, fact-checking. That's been the crux of our objection throughout. And, you're right, it should have been more specifically made, but I hate to think that the fight is over nothing. I get the court's point, but I think there's a larger issue here too, Your Honor, and I know I'm rambling a bit, so I apologize for that, but if, at least in my view, if Netflix is able to sort of wrap me into this, and I guess I understand the court's point, obviously, if I have relevant information they're entitled to, they should be entitled to it. But our point throughout this is, other than those 3 or at least that's the point now conceded at. None of this is relevant. It's certainly not relevant under the high standard of the reporter privilege in Wisconsin statute, which has a very high threshold, as the court, has pointed out in the statute. And what it does is it turns, instead of a case about whether Netflix defamed Mr. Colborn, it becomes a case of comparing making a murderer and Netflix rendition of this to Mr. Griesbach and Mr. Colborn and this documentary as yet unsold documentary convicting a murderer, and it just distracts from the central issues. They've shown nothing.
So hold on. So we're talking about discovery. We're not talking about what's going to be tried in this case, what the issues are in this case. Your response included a lot of assumptions about what will ultimately be decided in this case. What I'm trying to deal with here is a discovery issue. They've requested a number of specific documents in a subpoena. Until this phone call, I have heard nothing from respondents addressing the specifics of these requests, what the respondent has, what the respondent doesn't have. It's been just this big broad brush assertion of boilerplate objections, what I'd call, and then at the last minute this news person's privilege. But in all of that, in all of those objections, there's been no effort by respondent to go through the specifics of these document requests and say, here's what I've got. Here's why none of this has actually, none of this has anything to do with the specific issue in the case. There's just no analysis of the specifics. It's all at the very, very broad brush, high, treetop level, and it's really not helpful to the court. So all I've got right now to decide is, there are the boilerplate objections, which I made clear at the last hearing I was not terribly impressed with, and then this issue of the reporter, news person's privilege, which again I think at a broad level the problem here is that all of these materials are at least in theory and practically available to the plaintiff, and that he could use anything useful in them, and as I said earlier, not use and not disclose anything that's harmful in those materials. Whether there's anything helpful or harmful in those materials, I have absolutely no idea, because there's been no effort by respondent to tell me what he has that is responsive, if anything. So I'm left, addressing these objections at an extremely high level, and as I think I suggested at the last hearing, I have a problem with the plaintiff having access to all of these materials, and then being able to selectively use them against defendants, and then defendants being sort of at the mercy of plaintiff on that stuff. And again, we are just at the discovery stage. Anything that's produced out of these materials may or may not ever see a courtroom, may or may not ever be admitted at trial. That's not the standard. The question is, could it reasonably lead to the discovery of admissible evidence? And I've not had any sort of real good specific argument on that, other than the sort of high-level, broad brush boilerplate objections and this high-level assertion of the news person's privilege.
Judge, if I could just one quick comment. The supplemental brief where I was on my own case, the court's directive was to address the request to the extent they involved the reporter's privilege. And I made it really upfront clear early in my brief that it was only document request number 1 through 6 that I was asserting the reporter's privilege. And to go through each individual one, I don't think would have served any purpose, because that is the basis for my objection. These are not involved, differentiated requests. They're all based on the reporter's privilege. And I think the court sort of ignoring the statute that was the subject matter of the brief and whether I waived it. There is a much higher standard as to the requests 1 through 6, which involve the vast majority of documents they're asking for. So, I don't know what else to say other than what's in my brief. I understand the court's concern about not the inequity of the parties and the materials if one has certain materials. But the Hale case, had to weigh that and weighed that out. And I tried to distinguish in my brief why this is not a case like the Hale case, where the documentarians there did interviews, and footnotes talk about which interviews and how important the information is and how relevant, and tried to distinguish that between what I've done. The other briefs, Netflix had an opportunity to show how I had this information that was advantageous to just Mr. Colborn and not their side. And also the waiver issue was discussed in my brief. So I understand the court's frustration. I apologize for that. I should have probably handled this myself from the beginning, which isn't much of an excuse, but it's the reality. I would also, though, encourage or defend myself in terms of document request numbers 1 through 6, that the reporter's privilege is at issue, and there's a much different standard even to get just discovery. I'm not talking about, and I realize my prior attorney talked about admissibility of evidence at trial, but that's not the issue here. But the issue isn't regular relevance either in terms of pretrial discovery. It's the statutory criteria.
But the problem, Mr. Griesbach, is they are not serving the subpoena on you in your capacity as a news person. If they were, this is not you are not, if you were just out there having written your books, sitting out there as a third party, your argument, there'd be more to this, or less to this, frankly, less to Netflix's argument. But the reality is, you're not just a third party who's sitting out there on the sidelines. You made the affirmative decision to join plaintiff's legal team, and now, as a result of that, the plaintiff has access, theoretically and practically, to all of those materials that are responsive to the subpoena, and the defendants do not have access to those. And while I agree that the statute says that mere disclosure of the contents of materials or dissemination of those materials to the public is not a waiver, we're not talking here about a waiver that's based on the disclosure or dissemination of materials to the public. They're not arguing that this waiver occurred because you wrote your book, published your book. They're arguing that the waiver occurred because you joined the plaintiff's legal team. And that's a very, very different set of circumstances that I think the statute doesn't address. And so we've got a situation where a party is trying to invoke this privilege to prevent the other party from having access to information that party has. And in the attorney-client privilege in particular, but in other courts, even in the reporter privilege context, a party is not able to use the reporter privilege as a sword and a shield. And to me, that's exactly what's going on here. So it's not simply a matter of applying the statute because the statute, I think, does not speak to this particular context. It's a broader privilege issue, a broader waiver issue. And so again, I think the specifics of these document requests and the concrete issues that the court's just hearing about today, it would have been very useful to have heard about those previously, for those who have been raised in the objections, for those who have been raised with counsel beforehand, because maybe you could have convinced them that there's really nothing in here and that they don't really need it. But we are way too late in the day for that, for that kind of specific discussion and negotiation today. Anyway. Anything further from the parties?
Your Honor, April Barker again for the plaintiff. I just want to say for the record, I know we've already had this discussion, and I don't think we're really the focus of where this is going, if I'm understanding correctly. But, perhaps I'm wrong. The court may seem to think so, but it would have been my thought as someone very involved in Mr. Colborn's legal team that we would have had to subpoena Mr. Griesbach's personal documents if we had wanted them in this case, and we did not do that. And so to the extent there's a suggestion that we are practically handicapping the defendants with the use of Mr. Griesbach's documents, I can represent that that is not the case, but I think the court's analysis is more hypothetical. I guess to the extent that we would somehow be bound by any such ruling from the plaintiff's standpoint, we'd obviously, if that's ever relevant in the future in this case, we'd want an opportunity to actually brief that issue.
Well, so the point is, what Mr. Griesbach knew in his capacity as a news person back in before this lawsuit was filed, he knows, and it's in his brain. And as counsel for the plaintiff, he can share that with the plaintiff. He has no way of compartmentalizing his brain and separating that stuff off, so he doesn't share it with the plaintiff and say, okay, so that stuff's entirely off limits. So on some level, it's not a theoretical distinction. It's real. That's one of the reasons. Well, it's part of the whole sword and a shield analysis. But I'm ruling on. I'm going to rule on the motion to compel that's before me. I'm not ruling on anything else.
Thank you, Your Honor.
So let me say this. I thought this is an interesting statute. It's an interesting issue. I'm going to give you an oral ruling right now. I will likely try to write something up because I think there is a dearth of law out there on this statute in particular, but on these issues in general. But let me just start by saying it's the respondent's burden to support objections to a subpoena, and leaving to one side to begin the 881514 or 88514 objection. The court first finds that respondent has failed to support his other objections. The court rejects his relevance objections in paragraphs 1 and 2 of the objection. Relevance is not the standard for discovery in federal court. Rule 26B provides for discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, subject to certain considerations. It's not admissibility. To the extent respondent objected in paragraph 5 of his objection that these materials could never be admitted into evidence, the rule specifically says information within the scope of discovery need not be admissible in evidence to be discoverable. It's sufficient that it could lead to the discovery of admissible evidence. I think Netflix has satisfied this requirement. Respondent's role in pre-litigation events makes it likely that he may have discoverable information. I don't know that he does, but I don't know that he doesn't. That respondent later agreed to act as counsel for the plaintiff is not a basis for him or the plaintiff to shield discoverable information in his possession. Respondent's unsupported suggestions to the contrary are, I think, wrong as a matter of law, and there are a number of cases that provide this. Certainly, while complications arising from Mr. Griesbach's role as counsel could conceivably create a burden that outweighs the benefits of the discovery sought, and that would be an undue burden under Rule 26B. But the court finds that respondent has not come forward with sufficient specific evidence to support such an objection. Again, the objections and the arguments are painted in very broad strokes. There's a generic assertion and complaint about the burden without a more specific analysis of each request or of the specific documents, and that cannot carry the day. To the extent he addresses the actual, respondent barely, if at all, addresses the actual document request or the specific items requested, the number of responsive documents, the difficulty, if any, he would have in identifying, gathering, or producing them. None of that is before the court, and this stuff's been pending for a long time. He mainly argues that the subpoena as a whole is improper and improperly burdens him as counsel. But again, the plaintiff's role as counsel is something respondent's role as counsel is something he took on when he joined the plaintiff's litigation team. That's a choice he made, and he's got to deal with the consequences of that. It's also an issue, frankly, that plaintiff took on when plaintiff agreed to hire respondent with all of his background and history as counsel. Plaintiff has similarly failed to support his overbreadth objection. Again, there's nothing specific that would support overbreadth. That public sources exist for some of these materials that may be relevant in part under the with Stat 88514 to the extent the court gets into that burden shifting. It's not relevant as a general matter for discovery. Parties are entitled to discover the same information from more than one source. In fact, differences in sources can sometimes be relevant. Again, if the respondent had shown that the burden of obtaining the documents from, or the information from him was sufficiently high, and it didn't outweigh or it was sufficiently high, and the materials could be obtained from a third party in a much less burdensome way, and that was sufficient, that might be an argument that would preclude discovery. But there's no meat to that argument. There's just a generic assertion of it. Respondent has also objected in paragraph 3 that the information is proprietary. That's also not a basis to preclude discovery. The confidentiality order specifically governs that, and the materials could be marked confidential. So again, at this point, the court's not sure what responsive documents respondent even has. And a bit of evidence would seem to have been central to these objections, but there's none before the court, so the court rejects them. This leaves only the late raised WISTAT 88514 objection. Again, the court will interpret the statute as establishing a state law privilege for news persons that limits the discoverability and admissibility of information sought from a news person consistent with Federal Rule of Evidence 501. With respect to the timing waiver, Netflix argues that respondent waived any objection by failing to assert the privilege in his written objections to the subpoena. The Seventh Circuit has held that Rule 45C2B requires the objecting party to raise its objections before the earlier of the time specified for compliance or 14 days after the subpoena is served. It's undisputed that that did not happen here. The privilege was first raised on March 11th, 29 days after the service of subpoena, 15 days after filing written objections. I plainly could find a technical waiver here based on the delay, but I'm not going to do that. I think, as Ms. Walker acknowledged, ultimately there's really not any significant unfair prejudice And so to the extent there was a technical waiver here, the court will excuse it. But we get to the more substantive ground, which is the waiver argued by respondents joining of plaintiff's legal team. Netflix argues for that substantive waiver, even if the lateness of the objections did not result in waiver, respondent waived any right to invoke WSStat section 88514 when he agreed to join plaintiff's legal team. It points to Simon versus Northwestern University, a Northern District of Illinois case with very similar facts, although it involves Illinois' reporter's privilege. Respondent argues that Simon interpreted Illinois statute, which is different. That's undoubtedly true. Simon is not binding authority. It is at best persuasive. In fact, there's no case law applying WSStat section 88514, so the court's left to look at persuasive authority. But my function is ultimately to predict how the Supreme Court of Wisconsin would interpret and apply this statute and related doctrines. WSStat 88514 sub 4 provides that disclosure to another person or dissemination to the public of news, information, or the identity of a source by a news person does not constitute a waiver of the protection from compelled disclosure. That is what the statute said, but I do not think it means what respondent thinks it means. By its terms, this provision protects news persons from being faced with a waiver argument based simply on their having published portions of the facts that they've gathered while holding other ones back. Case law shows that this is a very common provision in reporter privilege statutes and decisions. In fact, it's, as Netflix notes, it's almost an inherent part of any reasonable reporter or news person privilege. It is inherent in what reporters do that they gather information and then report digested portions of that to the public. They disseminate it. If publishing an article based on parts of their fact gathering constituted a waiver as to all fact gathering, it would completely swallow the reporter privilege and make it a non-entity. But WSStat 88514 does not say that these statutory protections can never be waived in any circumstance. It merely talks about that the disclosure to another person or dissemination to the public does not constitute a waiver. But here the waiver argument is not based simply on a disclosure to another person or dissemination to the public. Netflix is basing its waiver argument on respondents' affirmative decision to join plaintiff's legal team, not on respondents' public dissemination of the information in his books. This is an important difference. Section 88514, as I said earlier, does not address this circumstance. Respondent also contends that 88514(1)B is drafted especially broadly to cover news persons even after they have completed their assignments. It defines a news person as any person who is or has been engaged in gathering, receiving, or preparing or disseminating news or information. But again, this doesn't address the circumstances of this case. If a respondent were simply a news person who had been engaged in gathering, receiving, or preparing or disseminating news information, his documents and information would be protected by the statute. Again, if it was just that he published books before this case was filed, he would be off limits from discovery. But that's not what is at issue here. What is at issue here requires application of a broader waiver concept not addressed in the statute. In the attorney-client privilege context, there are ample cases rejecting attempts by a party or lawyer to use the privilege as a sword and a shield. And it is that broader privilege concept, the sword and a shield exception or waiver, that applies here. Respondent in this case made the affirmative decision to join plaintiff's legal team. Doing so inherently caused him to share otherwise discoverable information with one side of this litigation, the plaintiff. There is in fact no way for him not to share it. He cannot compartmentalize his brain. He knows that information and plaintiff therefore has access to it. With plaintiff having access, plaintiff can then use that background and that information as a sword. And in these circumstances, the respondent and his counsel and the plaintiff cannot invoke the news reporter's privilege or the news person's privilege to shield that same information from the defendants. Privileges cannot be used as a sword and a shield. Netflix cites a number of cases that apply this. There are others as well. I note Ayala versus Ayers, 668 F. Sup. 2nd, 1248 from Southern District of California. Anderson versus Nixon, District of D.C. Driscoll versus Morris, District of Connecticut. Fisher versus McGowan, 585 F. Sup. 978, District of Rhode Island. So for all of those reasons, the court concludes that the protections of 88514 do not apply to protect respondent from having to respond to this subpoena. The court also notes, as I suggested earlier, that I think defendants could have also obtained this information by serving a document request under Rule 34 on the plaintiff because documents and materials within the custody of a party's agent are within the party's custody and control. If practically speaking, the party could obtain them from the agent. Accordingly, even if I would have found, and I don't, that with Stat 88514 applied to prevent a subpoena to the respondent, it would not apply to prevent Netflix from requesting these same documents from the plaintiff. And because they are within counsel's possession, they are also within plaintiff's custody and control. He has the legal right to request them, and he practically has access to them because he has access to respondents' counseling and experience. I'm not, and I raised the issue of whether Netflix had existing document requests that would cover these materials, and I appreciate that maybe they did, maybe they didn't. I will also make clear, though, that given the unfairness of allowing only one side access to otherwise discoverable materials, the court would, if the situation had arisen, reopen discovery and allowed defendants to serve new document requests to obtain this material. I would do that if I thought 88514 technically barred them from obtaining them through the subpoenas, but again, I don't think that's necessary. I appreciate that respondent and the plaintiff may not like this result. I have no idea how critical any of these materials are, again, because none of that has ever been presented to me. But I think respondent's suggestion that just because he's counsel, he doesn't have to comply with discovery is just wrong. And so when he agreed to take part in this representation, he kind of invited this issue. By serving plaintiff as counsel, he gives plaintiff access to this information. He gives him a sword. He therefore can't use the statutory privilege as a shield to prevent defendants from accessing this potentially valuable, potentially not valuable, I don't know, information. As I said, I will supplement this oral ruling with a written decision. I guess my next question is, again, I have absolutely no idea how much it's going to take to respond to these document requests, how much time this is going to take, and what this will do to the existing schedule. I guess I'd ask the parties whether any adjustments to the schedule are necessary at this point. Maybe you don't know. Maybe you need to talk to one another first. I'm sort of at your, I'm open to suggestions. Ms. Walker?
I think we should talk to one another first and come back to you if we need to push out Mr. Colborn's deposition. There's a lot of moving things in the case right now that you don't even know about and don't need to know about at this juncture. So let us talk, and we'll circle back if we need more time.
Ms. Barker, Mr. Griesbach, does that make sense to you?
It does, Your Honor. April, I don't know what you think, but I believe hopefully it won't change anything in terms of timeline here, but I don't think it's going to take me a great amount of time to deal with this. I'll obviously devote A lot of time to it in the coming week or two.
Your Honor, Attorney Barker here. I think Attorney Walker and I likely would have been talking about various discovery issues anyways, and I agree with her that we should touch base and let the court know if we think that scheduling adjustments are appropriate.
If I give you, what if I direct the parties to file a status report by June 28th? I'll give you 2 weeks, letting me know whether any adjustments to the schedule are necessary, and if so, you could propose them, and I'll take a look at them. If not, that will be done. If yes, you can propose some, and if they're acceptable, I can just enter an order adopting them, and if I have questions, we'd set another hearing. Does that make sense?
Yes.
Yes, Your Honor.
All right, that's what we'll do. Thank you for your time today. Thank you for the discussion. Any questions, anything further for this afternoon?
No, Your Honor.
No, thank you.
All right, thank you all. We're adjourned.
Thank you, Your Honor.
Thank you.